Hello, everyone. Welcome to our California Association of the Deaf presentation, live stream presentation for tonight. Tonight, we are very excited to have Christopher Knopf, joining us tonight. Our sign language interpreter is Paola Morales. Tonight, our presentation will focus on deaf rights, the Americans with Disability Act, and Section 504. I'm really looking forward to tonight's presentation. Christopher Knopf, please take it away.
Great. Thank you, Kavita. All right. Love this technology. Good evening, everybody. My name is Christopher Knopf. I'm with the Disability Rights Legal Center located in Los Angeles, California. We can go to the next slide. I'm happy to be with you and give you a little taste, a little introduction of disability rights and deaf rights under the law in California specifically, including some federal law. I will be speaking for a little while. We have a little presentation. I do this and we go to the next slide. Can we go to the next slide? There we go. Okay. Yeah, that's me. And that's the organization. Let's go to the next one. In any case, I am an attorney, as this shows. I want to be very clear that I am not here to give legal advice tonight. So please bear with me. If you ask questions, I'm happy to answer them, but I'm not here to give legal advice. Yeah, there we go. All right, now we're moving. We got this. This is a general overview. That's right. I'll give a little bit of background. I'll tell you about the Disability Rights Legal Center, some of the cases that we've done in the past, some cases that we're working on right now, and some advice for you folks out there. I'm sure that you encounter situations all the time and you wonder, when is it appropriate to call an attorney? And I'm going to give you a little bit of ideas in that regard, and hopefully help you out and know what to do when you encounter a situation. So just a little bit of background. We'll get into the laws. I've been practicing for almost 25 years. I had my own law firm for the last 14 years called Knopf Associates. And in last December, I rejoined the Disability Rights Legal Center. I grew up as a baby lawyer at the DRLC about 16 years ago. And it's just a real pleasure for me to return to my organization and work on these cases and mentor younger attorneys and do some real good in the world. So it's really a pleasure to be with you this evening. And with that, let's get into what are the discrimination laws. There's some that you already, I'm sure, you well know: the ADA, the Americans with Disabilities Act, and Section 504 of the Rehabilitation Act of 1973. Those are your major federal disability rights laws. There's also, as you may know, the Individuals with Disabilities Education Act, which is our special education laws. These are the general non-discrimination laws passed by Congress. As many of you may know, we have the 30th birthday of the ADA this month. So yet again, a wonderful testament to the progress of the law, and yet also a reminder of how much further we still have to go. So beyond these major laws that you probably have heard of, what else is out there? Well, we also have, let's keep going, one more. The ones that you may not know, the Affordable Care Act, otherwise known as Obamacare, has a great non-discrimination clause in it. And just yesterday, in fact, the Ninth Circuit Court of Appeals came down with a decision basically giving some teeth to the non-discrimination provision that says in healthcare and health plans, there cannot be discrimination against people who are deaf or hard of hearing. In that particular case, the plaintiffs had not alleged sufficient facts to substantiate their claim at the outset, but the important part of the case was the reaffirmation that the Affordable Care Act, much like the ADA, has some really good protections for people with all disabilities under federal law. So that was a great decision that just came out yesterday. The Mental Health Parity Act, you may or may not know what that is or have heard of that. The Mental Health Parity Act says for health plans that offer healthcare insurance or HMOs, that the mental health care has to be the similar level of service as physical health care. In other words, not discriminating against people with mental disabilities. And that's an act that my office would really love to bring some cases under and enforce the rights of folks with mental health disabilities. All right, beyond those two additional federal acts, we have various California statutes that we use all the time in our disability rights litigation. And the number one is the California Unruh Civil Rights Act. This is a very powerful act because in California, it allows us to sue for monetary damages for acts of discrimination. And you may know that Title III of the ADA does not allow for suing for damages. Section 504 does, but the ADA against private entities does not. So we in California are lucky that we can bring our cases for damages under the Unruh Act. All right, what else? We have the Fair Employment and Housing Act in California. This is a very important statute here in our state because it goes far beyond the federal laws regarding employment, Title I of the ADA, as well as the Fair Housing Act under federal law. The California Fair Employment and Housing Act has much greater protections for people with disabilities. And as we like to say in the legal profession in California, if you're suing under Title I of the ADA, it's probably a mistake. We want to be suing under the California Fair Employment and Housing Act. And then there's also something called the unfair competition law, which allows anyone who has harm to them due to an incident, anything unfair, unlawful, or fraudulent can be brought not only on your own behalf, but on behalf of the general public as well. So the unfair competition law is very helpful in being able to bring changes in policies and procedures on behalf of the greater community without having to file a class action, which is a little bit different and has different procedural requirements. So in California, again, the unfair competition law is very helpful and important. Okay. All right, what is discrimination? I probably do not need to tell you. Am I right? I think I'm right. Denial of reasonable accommodations, and then exclusion and unequal participation. These are the basics. And I imagine that many, if not most of you, understand this concept that if you are excluded from a place or an activity or a program because of your disability, that is discrimination under the law. Also, if you are treated substantially unequally, you don't get the same benefits as somebody else for perhaps in a school or in a theater program or any number of other instances. If you are receiving unequal or separate or segregated benefits, that of course is discrimination as well. What else? Harassment and retaliation. Of course, these are instances when you are mistreated, when you are bullied, or if you speak up on your own behalf and you receive some sort of consequence for that, whether in the form of exclusion or in an employment context, a demotion or a reduction of benefits, then that's retaliation. So each of these different types of discrimination are protected, or not protected, but are actionable under the disability discrimination laws. Any one of them, any combination of them. Okay, moving on. What else is discrimination? Lack of effective communication, obviously, and denying entry of a service dog. Wanted to highlight these items because they may apply to the deaf community. Obviously, effective communication, we'll go into that a little bit, but also denying entry of a signal or service dog for a place of public accommodation. This is private entities, stores, markets, hotels, restaurants, and such. If you have a signal or service dog, obviously, if they deny your dog, they say you can come in, but we're not going to take your dog. That's still, of course, discrimination under the law. Next one is also denying an emotional support animal in housing. Now, an emotional support animal and a service dog are very different. A service dog is specifically trained to perform tasks related to the person's disability. Okay, and that's a very important definition. And one should not represent an animal as a service dog unless it has had that very specific training. On the other hand, an emotional support animal, which can be something other than a dog, if prescribed or recommended by a psychotherapist or other healthcare provider, that having that support animal is permissible in housing situations. Very important to know that in places of public accommodation, they are not required to allow you to enter with an emotional support animal. So it's a distinction that was created in the law a few years ago. Only service dogs are allowed to enter private facilities. Technically, emotional support animals may not. Okay, next slide. All right, this is the definition of effective communication, that which is as effective as communication with people who are not deaf and hard of hearing. I imagine that many of you have know this definition and have applied it in your lives. There must be a provision of auxiliary aids and services at no cost when necessary to afford a person with a disability an equal opportunity. Okay, and so that's loops, sign language interpreters, captioning, could be any number of different services in order to ensure that the communication that you're receiving is as effective as that provided to others. Okay, and this is the general non-discrimination definition under the law applied to government entities. It's a little bit different for private entities, but I thought I'd put the general non-discrimination term up there for you. No qualified individual with a disability by reason of that disability may be excluded from participation or denied benefits of the services, programs, or activities of a public entity, or subjected to discrimination by any such entity. And this was Congress speaking 30 years ago, saying, you know, we are done with excluding folks. Let's bring everybody into the fold of our community. So we've come a long way. All right, here's a big question I know that your community asks. I hear it a lot. Do they have to give you what you want? Do they have to give you an ASL interpreter when you demand it, right? Big question, and it's not necessarily the answer you want to hear, okay? The real thrust is the definition of effective communication. Is the communication reasonably effective? Whatever the means are. And why do we say that? Because it's different for government and private entities, and it depends on the situation that you're in. If it's a time-intensive situation, obviously there may not be opportunity to get you the the service that you want. If notes will suffice in a given situation, that can be considered effective under the circumstances. It all depends. If you go into a hospital, do they have to translate the papers that they have you sign? Do they have to call an interpreter for that? In an emergency service situation, they hopefully will have a system in place where they can do that. But will they be held legally liable if they don't? It's an open question. Now, if you have time and you can request an interpreter and say, I'm not going to sign these papers until these are interpreted and I understand them fully, and you have the ability to wait, then arguably there's an obligation that the hospital should call in an interpreter. I know we all know what they do instead. They try to get their VR to work, and then their VR doesn't work very well. So an ongoing problem we see all the time. Okay, but it does depend on the situation. There's no easy answer. Oh, and also, did you make a request ahead of time? So if you arrive for a doctor's appointment and say, where's my interpreter? That's gonna probably be held unreasonable. But if you called the doctor's office some time before your appointment and said, I'm deaf and I need an interpreter for my appointment, I'd like to make sure that one will be available when I come, then you have a much better argument that the doctor should have provided an interpreter for that appointment. So whether you requested one ahead of time or not is an important question. And there's the whole question here is reasonableness. What is a reasonable person going to think should have happened under the circumstances? And you really have to keep that in mind and not necessarily assume that they're going to give you what you want right off the bat, okay? All right, when should you call a lawyer, right? Well, you would go through your daily life, and I know that it's happened many, many times in your lives. Here are some questions to think about in terms of this question as to when you want to call a lawyer. Has harm actually occurred, or will it occur? If something's already happened to you, or if you're going to go to this situation, school, event, or other program or activity that that you're not going to be able to participate because of your disability. That's one primary question. Now, what is harm? I've given here 3 possibilities of what that could mean. You lost an opportunity, or you didn't have an equal opportunity. It was emotionally stressful or distressing based on how you were treated. There was monetary loss. 3 examples of how harm might have occurred. Okay, now, in a situation where you think it might not go well, but you're really not sure and haven't made any inquiries, that's kind of a hypothetical situation that hasn't quite happened yet. So that is not the time necessary to call a lawyer unless you're seeking some information ahead of time about how to advocate for your rights. But in terms of, I think that person's or that program is going to discriminate against me, not yet. Harm has not yet occurred. Okay. All right. And then what's a really good rule of thumb is the reasonableness inquiry. Have you taken all reasonable steps to be able to help yourself in this situation? Now, it's not necessary that you do that before calling a lawyer, or that you have a viable legal claim, but it's always a really good idea to take the reasonable steps that one would think that you would take to try to resolve a situation yourself. Have you sent a letter or an email to the business or the entity in question? Have you tried to get a resolution? Those are all really important things to try to do before marching in and demanding that a lawsuit be filed. Okay. All right, let's keep going here. At the same time, once you feel you've been wronged, and you feel like there very well could be a legal claim, and you feel you've taken all steps that are reasonable under the circumstances, don't delay. Don't wait 6 months. Don't wait longer than that. With government entities, if we're talking about a city, a district, or a state government entity, there's very strict legal timelines. You have to bring an initial complaint against that government entity in California within 6 months of the incident. Now you're given another 6-month grace period, but you have to then request the right to bring a late claim in that instance. So my, suggestion is, if something has occurred to you and you want to enforce your rights, don't delay in getting an appointment with an attorney. You're going to probably look it up on the internet, aren't you? I think so. Just be really careful the resources that you rely on. Make sure they're reliable. I have a few at the end of this presentation to get you started in terms of knowing what the law is. There's some really great technical assistance manuals through the U.S. Department of Justice that I really recommend reviewing because it's very plain language, easy to follow. Examples and questions that come up in daily life about what one's rights are and what one's obligations as a business might be. I'll show those to you at the end of this presentation. But just be careful what we rely on the internet. Goes without saying, but I don't think I could actually say it enough. Okay, and then there's always the contacting the lawyer for a consult. Many lawyers, will meet with you or have a conversation, for a half an hour to an hour to review your situation. You want to make sure they have the credentials to listen to your matter. I would recommend that you call a disability rights attorney. If you have a disability discrimination claim, don't talk to a family lawyer about it or a trust or whatever criminal lawyer. There's lots of great disability rights attorneys out there, and that's who you want to talk to. And then, when you're ready to file a complaint, like I was talking about with a government entity, it's a really good idea if you can to try to contact an attorney and, present them with the situation. Say, I heard this lawyer talk about a government claim I have to file within 6 months. I want to make sure I'm doing this right. That's a great time before you file it to contact an attorney as well. Okay. All right, so Disability Rights Legal Center. This is my office. We've been around for more than 40 years. We've litigated cases on behalf of individuals, on behalf of groups and other nonprofits like GLAD. We've done a number of cases with the Greater LA Agency on Deafness. We've represented independent living centers and other groups. And then we've filed lots of class actions over the years. As well, just so that you're aware, the DRLC also has a Cancer Legal Resource Center, which is almost a one of a kind services where you can call or inquire online if you or a loved one or a friend has cancer and has legal questions that arise, such as employment questions, insurance questions. Either we can directly answer those, or we can refer you to a volunteer attorney who specializes in the area that you need and can get you some direct answers for those questions. And that's true actually not only for cancer-related issues, but for any kind of legal issues that we don't handle or can't handle. We try to provide really good referrals to attorneys who specialize in that area of law. So even if it's not a discrimination case or a cancer matter, if it's just some legal assistance, we can provide some assistance when referring to attorneys in certain fields. But we have, we've had some really phenomenal cases over the years. Lately, my own practice, as I mentioned, for the last 14 years, has really focused a lot on school litigation. K-12 is the special ed area of law, which we do at DRLC, and there's a wonderful group of attorneys throughout California, really dedicated advocates for kids and families of kids with special needs. And as some of you may know about the, I believe it was the Tustin case, which required that for that particular child and similarly situated children who are deaf and hard of hearing, captioning can be requested in a school environment. And in some cases, it will need to be provided. So a very big Ninth Circuit case in that regard affecting the deaf community. But DRLC right now has a number of higher education cases as well. We're, one of our recent focuses is on the person trying to achieve the career that they really want to have. And oftentimes there's just so little support out there for navigating the bureaucracy and the roadblocks that come up in colleges and universities, vocational schools. And I really have litigated against a lot of schools, and it's unfortunately a continuing problem. And it's against major universities and schools that you would think would be a lot more supportive, but for whatever reason, there's still lots and lots of challenges. So we're focusing a lot on the educational context, building that foundation for equal opportunity in one's life. Hospitals, as I mentioned, we talked about it. As you know, an ongoing problem, an ongoing issue. So we are taking those cases. I settled a couple of those cases in my practice over the last couple of years. And it is this issue of, the VR not being good enough and, needing a sign language interpreter to really have effective communication. And as I mentioned, again, depending on the particular situation, there very well could be the requirements for the hospital to have a contract with an interpreting agency, or if by some miracle they make VR work better someday, we can only hope. And then police cases as well. We've been doing some work lately on behalf of a gentleman in a different state, actually, because some of our cases are outside of California, who was a protester, who was deaf, and he was not aware that there had been an order to disperse the crowd, and he did not realize it because there was no visual cue or any kind of visual communication whatsoever to allow him to know that he needed to go, or the police would, use some level of force. And that's exactly what happened. He ended up, I think, getting shot by rubber bullets, and having some level of injury. But we are looking into this issue in this day and age of protests, and so important to allow as well equal opportunity to protest without, unreasonable harm. So if you or anyone had issues in the recent protests, certainly recommend you give us a call on that. We are looking at that issue. Historically, I was just telling my staff earlier today that one of my most favorite cases that I've ever worked on in my career was that of Sanford Diamond against the Los Angeles Police Department. And I related the incident where he was in an argument with a gentleman in a parking lot and started signing vigorously. The police were called in, and they had no idea that he was signing, and they took his behavior as violent conduct, and they cuffed him and they tweaked his shoulder, put him in the hot car for hours at a time. And out of this case, this was back in, I think, the early 2000s, we ended up bringing a class action lawsuit. We got a consent decree against the LAPD, City of LA, and that, we hope, started at least the education of the LAPD to improve its policies, improve its training. Anything of that nature that continues to happen today, we definitely want to hear about it. And then, as I mentioned earlier, we don't do employment law, and some of you may be ready to ask me a whole bunch of employment questions. I'm not going to be able to answer them. So we don't do that. But again, there is a great, wonderful community of employment warriors out there who, are ready and willing to speak with you about any employment discrimination concerns that you may have. And DRLC will put you in touch with those folks, if that's necessary. Okay. Oh, the other, actually, can we go back one slide? Sorry. Nice. Oh, yeah, there we go. Thank you. The one other case I wanted to highlight in terms of what we're working on right now is the metro system in LA. We're looking at the effective communication and the various communication efforts that MTA or Metro uses in the functioning of the trains. So if you or someone you know has had difficulty or had a particularly egregious incident where the lack of communication resulted in a very difficult circumstance or even harm, again, I would encourage you to contact our office and let us know about that. That's of interest to us. And Kavita and the folks at CAD are helping us out. You'll be hopefully getting some communications in that regard. And we would very much appreciate that assistance. Okay. All right. So in terms of getting help from us, you can call us using your service. You can email us, or there's a really wonderful, easy intake system online at that link, the drlc.org/intake. It's a complete intake questionnaire. You fill it out. It goes directly to our team. We review it. If it has a potentially viable disability discrimination angle, we will talk about it as a team of lawyers, and we'll often, choose cases to investigate further. And we will contact, you or your friend or loved one for more information. And that's how we get the process started. It's very easy. Okay, and I think that's basically it. Let's see, what's our next one? Yep. Okay. Other resources. Great. So, perhaps before calling us or as you're investigating your rights, or the different resources and authorities that are out there, your local independent living center is a great resource. I work with independent living centers all the time. My friends TJ Hill and Lilibeth Navarro, I don't know if you know them in the LA area, but they're wonderful folks who are doing great work. And I encourage you to contact them for a variety of kinds of needs. Obviously, GLAAD's terrific in the LA area. Now, these other websites are really fantastic informational websites. ADA-TA refers to the ADA Technical Assistance, and it's not technically a government website, but it's I think it's a very informative, very robust site with information for you to review. ADA.gov is run by the US Department of Justice. And if you look up the technical assistance on there, you can look up settlement agreements that have occurred across the country. You can do a search, for deaf rights and get a lot of information. And if you haven't heard of DREDF.org, that's the Disability Rights Education and Defense Fund. They're up in Berkeley, and they are, one of several warriors. Like Disability Rights California didn't have room there, but Disability Rights California is another. Just wonderful advocates, wealth of information, and trainings and attorneys and so forth. So those are some sources to get you started with that. If there was a timer, I don't see it, but I'm basically done with my presentation. I hope it's been a good introduction for you. We could go on for a lot longer, and I'm willing to do it if Kavita gives me a call. But that's a brief introduction to you on what the Disability Rights Legal Center does, some sources of information available to you, and some basics on your legal rights. So with that, I will open it up and we'll take some questions.
Christopher, thank you very much. That was a wonderful overview. There's a lot of work that you are doing, and it's wonderful for our community to know about your work and all of those disability justice warriors that you have and are working in collaboration with. Chris, I know you're probably familiar with the California government and their different announcements regarding the face mask. They've made some announcements regarding the effectiveness of communication when it comes to communication between, anyone that's communicating with deaf and hard of hearing individuals. So, what is your recommendation? I mean, we are thinking that, of course, communication needs to happen. I mean, that's the right, the normal thinking, and we don't want barriers in communication. There are some that are for wearing masks, some that are not supporting the uses of masks. So, I mean, we're thinking accessibility, but we're also thinking safety. What are your thoughts?
My thought is it's a very difficult question, isn't it? No easy answers here. And again, often it really depends on the circumstances and what we're talking about. If it's an emergency health situation where, a life is on the line, doctors are going to have to do what they have to do. That's their first priority, is preserving life, right? So, there's that kind of aspect to it. There are less urgent situations, perhaps initial consultations, initial entry to a hospital, that depending on the situation, there very well can be, a discussion, a meaningful exchange of information as to what's needed for effective communication and what can reasonably be provided. So number one, my number one recommendation is your rights don't necessarily go out the window here. Have the discussion. If someone is with you or you have an interpreter, even better. But your rights are protected up to a certain point. What I can tell you is that the standard had evolved. Initially, when Governor Newsom came out with his guidance, the disability community, including the DRLC, responded saying this is not good enough. You need to protect the rights of people with disabilities in a variety of ways. Rationing of care was a really big concern, where if it got really intensive, which it is now, how would they prioritize folks with disabilities? So that remains a really big concern. What I would suggest is looking at the websites for Disability Rights California and DREDF, as I had mentioned. There are wonderful pieces on there regarding exactly this issue, including that of masks specifically.
Great. I'm sure our audience will be looking at that website. Thank you for sharing that information. Our next question, question number two. The DRI is the current communication, but the TDI is something that's not being used. So when I think about my bank situation, my online banking access was suspended. I had to go through the actual bank and prove to them that it was me, that I was actually using the TDI services to access the information via the customer service representative. So, what can we do? What are the steps that we should take in order to access our banking services, for example, through the TDI?
Hmm. Thank you for that question. Very difficult situation. They're trying to verify an identity. You're just trying to get your banking done. I get it. That's really tough. And all I can say to you is this. Obviously, the banks have a legal obligation to you. They have to act reasonably and fairly swiftly to be able to get what they need to get done and allow you to get what you want done. What are the specific requirements that they have to go through? I mean, I can't really answer that question. All I can tell you is they need to have that interactive process with you to figure out a solution and one that works for you. It's in this environment, it's very tough because a lot of folks don't want to go physically to the bank. So how do they verify it? Again, it's a very difficult situation, but with Zoom, and video, there should be a solution that is achievable in fairly short order. So, requesting to speak with a manager up the chain obviously is what you're going to do in that situation. And presumably at some point, someone's going to have the authority to okay your services. But if you have a roadblock and you are prevented from doing what you need to do, or the bank is taking an unreasonable position and you can't get anywhere, then that's when you call an attorney and have them contact the bank on your behalf. And if you're able to retain an attorney, you probably get it done within a day or so. The nonprofits may or may not be able to handle that kind of particular situation. But again, you want to provide as much self-help as you can get in that situation. You don't want to rush to the place of calling an attorney first. You want to exhaust all the possibilities available to you in working with that bank to fix that situation. So sorry about the generalized response, but that's the best I can do for you here.
Yeah, it's really a very challenging situation when you think about the pandemic that we're in and some of the verification requirements that the banks are imposing on deaf and hard of hearing. So now, if looking at the Section 504, if there are some issues with this meeting the Section 504, that it's in an area outside of the area that you serve, uh, because they live again outside of the area that you serve, can you provide any type of support or assistance?
Okay, I'm not really sure the nature of the question, but if you're saying outside of California, there's obviously each state has its own set of state laws. There may be some.
No, no, no. You're based in Los Angeles, right?
Correct.
And who should we contact to talk to someone about Section 504?
Okay, so could be a couple of different things that you're asking there. So there's, the Department of Rehab is one thing. I'm not sure if you're referring to issues with the Department of Rehab. Section 504 is like the ADA. It was a precursor to it by 17 years. And it basically is a non-discrimination statute for any entity in the United States that receives federal funds. So if you're an entity, whether it's a government entity or a private entity receiving federal funds, then they have an obligation not to discriminate on the basis of disability. And so that's just a legal theory. That's a lawsuit that can be brought in court, just like under the ADA, or if you're in California, under the Unruh Act, or one of the other laws that I mentioned. I hope that answers your question, but if not, go ahead and follow that up.
I believe that answered the question. You mentioned a timeline for filing a grievance. So if a deaf or hard of hearing individual faced discrimination in school or in housing, you said the time frame was exactly what in order to file a complaint?
Okay, so shockingly, my answer is it depends. It depends on who we're talking about. If it's an entity that has its own internal complaint process, you can and should go through that internal complaint process, file the complaint, try to get a resolution as we talked about. But that doesn't mean that you have to wait forever, right? You file a complaint. If you don't get a response within a reasonable time, you can take the next step. You don't have to wait for any process that would be deemed futile. If it's futile and there's no point in going through it, the law, has a provision in it in certain cases, or you don't have to follow the internal process. Generally, it's a good rule. If your complaint is against a government entity, in California specifically, you have 6 months from the date of the incident, or if it was multiple incidents, from the first incident is the safest one to calculate from. If it's a continuing conduct, it happens all the time, then you can go from the most recent date. But to be safe, go from the first incident. 6 months from then to file a government tort claim. And if you're beyond the 6 months, there is a second 6-month period where you can file a late tort claim. Again, I do recommend that you contact a lawyer for that if possible. If not possible, if you're not getting someone to return your call, make sure you file it yourself. Try to adhere to those timelines. They're very important to preserve your state law claims against that government entity. Now, the good news is if you are just going under federal law, ADA or 504, then that tort claim, that initial step, doesn't necessarily apply. Or if you are beyond your 1 year, then a lawyer can still look at your case, and if they like your case, they can still file under federal law. It's a bit complicated there, but the point of this is that if there are these kinds of complaint procedures, I do recommend you go through them. I do recommend you contact an attorney if possible to get some guidance. And I'll just add, sorry to answer the question further, Kavita. In California, we follow the personal injury statute of limitations, which is 2 years from the date of the incident that we were talking about. And that's generally for discrimination claims in California. There's some law that extends it to 3 years. We don't want to bank on that necessarily, but for your purposes here, remembering 2-year statute of limitation for ADA claims is a general rule.
Oh, that's fascinating. Okay. So again, if there's any type of discrimination that's being experienced, there's the internal processes, and if not, any time during that process, they can contact your offices.
Mhm.
I believe we have one more question. Now, if we have deaf parents with deaf children that are in the K through 12 educational system, can the parents request having a certified deaf interpreter that can provide communication during the IEP meetings, maybe in a mainstream environment? Again, deaf parents have the right to request a certified deaf interpreter to be present for communication at a K through 12 environment?
Great question. Love that question. So I want to answer it a couple different ways because I think maybe you asked it in a couple of different ways. If we have a deaf child, there's a certain set of rights that attach to that deaf child under the special education laws, right? Very specific as to what those child's needs are. Those needs to be Those needs need to be met in order to allow that child to make meaningful progress in the curriculum. So that's one angle. But I love your question because it's what if the parents are the ones who are deaf? And what are their rights? And under the special ed laws, the IDEA, Individuals with Disabilities Education Act, and there's also state law that supplements that. Very important piece of it is the opportunity of the parent or guardian to actively participate in the process. And as you may know, a child's IEP, their educational plan, cannot be implemented legally until the parent or guardian signs off on it. So therefore, that parent's rights are extremely important. And if effective communication is required to participate in an IEP meeting, and that effective communication requires a CDI, then that request needs to be made sufficiently ahead of time, because as we know, CDIs are not as prevalent as interpreters in general. You want to give that district sufficient time to be able to locate one. Obviously, if you have some resources to share, I'm sure the district would appreciate that in terms of who to contact, but they will have to contract with somebody to provide those services. So keep that in mind. That's not something that can happen the same day or the next day. You want to give plenty of notice of your request for whether it's a CDI or just a regular ASL interpreter. Give plenty of notice, and they do have to require that, absolutely.
Christopher, that is a wonderful opportunity and answer, really. We do have certified deaf interpreters and deaf interpreters that would be available to provide this wonderful service at the time of need, and working with deaf children and hearing parents or deaf parents that have deaf children. It's really wonderful to know that these are the options. You've covered so much in this overview, and through the question and answer period, I want to take the opportunity now to give you thanks for participating. I'm really appreciative of your presentation. I want to thank our team, our moderators that were here during the whole event, and our technical team, which are in the background. Jermaine, who's our vice president, Jermaine Cornish. You may not be able to see him because he is our tech person for tonight and taking care of all the technical aspects for Access tonight. There is a survey. Ming Chen, Yang, and Darcy are taking care of the Q&A portion throughout our presentation. So if you do like this platform and how it was all put together by everyone in the team, please visit our website, the California Association for the Deaf website, and find out what topics are coming up. And if you have ideas on topics or presenters, please email us, reach out. Next week, you may already know, we are celebrating 30 years of the Americans with Disabilities Act. So we are definitely focusing on our rights and any issues regarding people with disabilities. Next week, we're hosting a panel that will feature the hot question of what is the AB5? What is AB5? So I look forward for your participation during that event as well. Have a great night, everyone. Thank you for joining us tonight. Good night.
Thank you.